Good morning, everyone. Those of you on the right side of the Atlantic, those of you in Europe, it's late afternoon. I'd like to thank you all for joining us today. My name is Patrick Leonard. I'm a barrister practicing in Dublin, and I'm a member of Arbitration Ireland. I'd like to thank Francois and Hannah for giving us an opportunity to do this joint webinar with the British Virgin Island Arbitration Centre. Both myself and Hayley, who is the other Irish representative on this call, are with Arbitration Ireland, which is an association of practitioners in Ireland dedicated to promoting Ireland as a venue for international arbitration. So today we're just going to look at a couple of issues between Ireland and the BVI in terms of arbitration, why it is we chose arbitration, and how we both market our venues as small regional centres in the field of international arbitration. So we're going to start off with just a little bit of introduction. I'm going to just say a few words about myself and I'll pass on to the others. And then after that, we're going to talk about why both of us have chosen UNCITRAL as the model law, or rather the arbitration law for our respective countries. We both come to it with different histories. Ireland, as you will hear, was closely allied to the United Kingdom until relatively recently and followed their system. And we've now diverged from the United Kingdom. British Virgin Islands, Francois will tell you, is a slightly different history. So in terms of who I am, I'm a barrister practicing in Dublin. I practice in both commercial litigation and arbitration. Most of my work in arbitration is in commercial arbitration, and mostly as counsel rather than as arbitrator. I do some arbitrator work as well. I've been practicing for about 20 years. I'm a senior counsel here in Dublin, and I've got a specialist interest in the field of international arbitration. So I'll pass you on now to Hannah. She'll tell you a little bit about herself, and then Hannah, I'll ask you to pass the baton on to Hayley.
Sounds great. Thank you very much, Patrick. Hello, everyone, and thank you for joining us today for this seminar. So I'm Hannah Dumal. I'm the registrar of the BVI International Arbitration Centre. I worked at several different law firms before in Hong Kong, in DC, and in Paris. I also worked before in other arbitral institutions. So my work at the center is to lead the secretariat and manage the cases. Hayley, to you now.
Thanks, Hannah. Yes, just introduce myself. My name is Hayley O'Donnell, and I'm a barrister practicing at the Law Library based in Dublin in Ireland as well as Patrick. And I have a general civil and commercial practice, much more junior than Patrick. I've been qualified since 2014 only. I have previously worked with the International Centre for Dispute Resolution, and I sit on the Arbitration Ireland Young Practitioners Committee. And I'm really looking forward to today, and thank you for joining us. I might just pass on to Francois then.
So hello everyone, I'm Francois Lassalle. I'm the CEO of the BVI International Arbitration Centre. So I've been around in the BVI for about 6 years now. And the idea was to move here to establish the institution and to help the jurisdiction move into the arbitration field. Prior to this, I spent about 15-20 years in London, working mainly for law firms, among which were Duntons and Linglaters. And before that, I was part of a startup. I worked for Standard & Poor's, I worked for Merrill Lynch, and so on and so forth. So kind of a mixed martial art background, if I may say, which landed me in arbitration. And that's it.
Okay, thanks very much, Francois. So first thing we want to chat about is why both of our respective jurisdictions have decided to use the UNCITRAL model law. It wasn't necessarily an obvious choice for Ireland. Hayley, can you talk a bit about the evolution of arbitration law in Ireland and how we've ended up with the UNCITRAL model law?
Yes, thanks, Patrick. So the UNCITRAL model law itself was first adopted in Ireland in 1998 through the Arbitration International and Commercial Act 1998, which enabled effect to be given to the model law in international commercial arbitrations only. So at that stage, Ireland already had an existing Arbitration Act from 1954. So while in 1988, with the introduction of the International Act, Ireland could at that stage say that it was open for business for international arbitrations, the introduction of the 1998 Act meant that from at that stage onwards, there were two different statutory regimes applied to arbitrations in Ireland, depending on whether a particular arbitration was domestic or international. And it also meant that because there wasn't a huge amount of international arbitration happening at that time in Ireland, it was felt that there was less widespread familiarity with the model law than desired amongst domestic practitioners, which is of course understandable at that stage. And so in order to consolidate that legislative framework and in respect of arbitrations generally in Ireland into a single source and to update that law, the Arbitration Act 2010 was then introduced here, which is a piece of legislation that is ultimately very closely modelled upon the model law and which is now the principal source of arbitration law in this jurisdiction. And I think it's probably fair to say that Ireland came to choose to adopt the model law at both stages because obviously it modernised Ireland's statutory framework and also because of the model law's inherent advantages, which include that it continues to represent internationally accepted standards of arbitration, and it has the obvious benefit and attraction of international recognition. And I suppose in that vein, it also provides a seal of approval from the United Nations. It means that potential foreign practitioners can rely on a minimum approved standard here in Ireland. And I think one of the main changes in Ireland and the driving force in adopting the model law was that the Arbitration Act 2010, in adopting the model law, abolished the case-stated procedure that had existed here, whereby arbitrators could refer to the courts a question of law arising in the course of an arbitration. And it also narrowed the grounds for setting aside an award and generally decreased the amount of possible judicial intervention in the arbitral process, which is obviously a huge benefit to parties to an arbitration who've agreed to obviously avoid litigation where they can. And so the adoption of the model law here in Ireland ultimately represented a shift in favour of the binding nature of arbitration and was, I think, a reflection of where Ireland was in terms of attempting to establish itself on the world stage at that time as an attractive seat for international arbitrations. And the 2010 Act and its adoption of the model law here has been very successful, I think.
Maybe can I just ask you, I suppose I know this, but others on the call wouldn't know it. Prior to the 1998 and 2010 Act, I think the Irish law was governed by the 1954 Act.
That's right.
And that was a copy and paste, in effect, of the United Kingdom Act of 1950, I think. Isn't that right?
That's right. So, as most of you will know, until 1922 and the establishment of the Irish Free State, here in Ireland, we operated under the United Kingdom system and effectively had the same laws as them. And so the first Irish Arbitration Act to be established was the 1954 Act, which was done to make provision in respect of arbitrations here, which dealt with fundamental matters regarding arbitration. And then the 1954 Act came in, which, as you say, Patrick, was ultimately a copy of the United Kingdom Act. There are very few differences between the two. And I think traditionally the Act was used for the three main sectors using arbitration at that time, which were insurance disputes, construction disputes, and law society conveyancing disputes. And then there was a slight amendment made to that 1954 Act in 1980 here with the Arbitration Act 1980, which enabled effect to be given to the Washington and New York Conventions.
So the choice was made to diverge from the UK system effectively. It was a fork in the road in the late 90s.
Yeah, that was the first major divergence here in 1998 with the introduction of that International Act and the adoption of the model law in that context.
Francois, did you have the same system in British Virgin Island? By its name is obviously linked to the United Kingdom as well.
So true. So, well, a little bit of history. The BVI is indeed an overseas territory of the UK. So prior to the 2014 Arbitration Act. It's actually the Act 2013 that was that came into force in 2014. The BVI was also operating with the 1954 UK Act. But when it came to make a choice and to either switch to the 1996 Act or to follow the UNCITRAL model, it was really a no-brainer, to the extent that although it wasn't done to separate the jurisdiction from the UK per se, it was more related to the fact that because we were about to create a new institution, we needed people all around the world to recognize what we were doing. And Haley just talked about global accepted standards, and that's what the model law provides. You know, someone who knows about arbitration anywhere in the world will know and recognize the model law as a global standard, and it helps with enforcement and so on and so forth. The rationale was also that because we were creating an institution, we were going to have to create rules. And we wanted those rules to be recognized by arbitrators globally, because we knew that off the back of the offshore business in the BVI, we would get cases originating from pretty much everywhere in the world. And so to that extent, we needed arbitrators in, you know, Singapore, Hong Kong, Africa, South America, and everywhere else to be able to arbitrate under the BVI IEC rules. And so our rules are also based on the UNCITRAL model law. And what the BVI did was argue, and I wasn't here when they did that, so I'm sending credits to people that were here before my time brainstorming on that. Not only did they pass legislation that was based on UNCITRAL, but they also prioritized flexibility. So the Arbitration Act in the BVI is not a copy and paste from the model law, but they built opt-ins and opt-outs to increase flexibility and to give parties, which is the core of the arbitration concept. It's to give parties freedom of choice for a wide range of things, and our legislation enables them to decide whether a court will have jurisdiction for appeals against an award, whether a tribunal will be able to consolidate arbitrations or limit the tribunal to a single member and things like that. So these are the reasons why at that point in time, the work group that was working on morphing the BVI from a litigation-only jurisdiction into a dispute resolution jurisdiction decided to follow the UNCITRAL route.
In terms of, you know, the using the UNCITRAL rules, one of the things that I suppose Ireland sells as one of the main reasons for it is the lack of court intervention. And there's quite a distinction between the amount of court intervention possible in other systems and under the model law, and certainly in our system. And we've got a single judge, Judge Barneville, who hears all arbitration matters. How receptive are the BVI courts to intervening in arbitration?
They do not interfere, and that's the good news. And I'm you know, this precedes the establishment of the arbitration center and the institution here in the BVI. You know, and we need to go back into a little bit of history here, but there were ad hoc arbitrations under the Act before the BVI IEC was created, and the long-standing tradition of the commercial court here in the BVI, which is a highly sophisticated commercial court, was not to interfere with arbitration, but to support arbitral tribunals in dealing with arbitration effectively and move the process forward. So there is a long-standing tradition of the commercial court supporting arbitration, and that has further improved with you know the formation of the institution itself.
And can I ask you, Francois, one of the things that is important for international clients, if there is no recourse to court, is to ensure that there is an adequate body of qualified arbitrators to hear disputes, because obviously there's no point in having arbitration as a one-stop shop if it's not a very good shop. Just by reference to geography here in Ireland, we have, apart from people in Ireland, we have people who can come from abroad here. It's quite easy for us to source very, very well qualified, experienced arbitrators. You're a bit further away. How do you ensure that you have suitably qualified people? Do you have a panel, or how does that work?
A bit further away is kind of an understatement. We are 5,000 miles away. We do have a panel, and there is a really positive story there. So, and we'll talk about it when we talk about theme 2 and why we got to where we are. But the BVI was never created as a domestic arbitration center. It was always meant to be an international arbitration center to deal with international commerce disputes. Off the back of the offshore industry, because the Caribbean, you know, if you get a dispute between 2 small islands in the Caribbean, it is usually in an international contract per se. And because we are at the crossroads of the Americas as well, and we want to get the deal flow between, you know, North America and South America, we were always going to want a panel that would cover Asia, Europe, the Caribbean, and the Americas. And so one of the first few things that we did back in 2016 was to invite a very eclectic mix of renowned, good arbitrators to join our initial roster. And I remember having those conversations with the board of commissioners of the arbitration center at the time. We were planning to send 200 invitations to people in like 42 different countries, I believe. And I remember me saying at that board meeting, if 50 people believe we're doing something that is interesting, then we are in business. If they understand the act and the rules and why it might make sense to have an arbitration center in the BVI and not just a commercial court. If 50 of them say yes to that and agree to arbitrate under our rules, then we're in business. Within 2 weeks, we had 193 positive replies. And so that was a really good shock to have. And so our panel has grown since. We have a slate that opens every year where we receive applications to join the panel of arbitrators, and we've got an appointment, a panel appointment committee that reviews applications and make a selection every year. So I believe we now have, and Anna, please do correct me if I'm wrong.
I was about to follow up on that, because we had a press release recently and we reviewed the numbers. So we have panel members from over 40 countries and speaking over 20 languages. And we are working very hard on this because we really want to have a diverse panel. We know we don't have enough arbitrators from Africa, for example, or from South America. And we know we have disputes involving those continents. So we're working very hard to attract and show users of arbitration that they can choose people from our panel.
And if you look at the panel of the arbitration center here in the BVI, and you scroll to UK, you'll recognize a lot of the names. You'll find those names, on the LCIA website and on the Hong Kong International Arbitration Center website. So, the other thing that we did when we created that panel and when our strategy to grow it is also to look at younger practitioners that offer a better diversity than what you would find on some other panels of some other institutions. And also we knew that our caseload would be constrained within the first 5 to 10 years. So, you know, we needed people that would be in their prime in 5 to 10 years from now, and working, you know, not at the beginning of their career. We do require some expertise and some, you know, real experience of arbitration, but people that you know, did not necessarily do this for the last 30 or 40 years of their lives. So we've got quite a good mix of younger practitioners and more experienced practitioners. And Hannah will be able to say, you know, when we get to select arbitrators, we'll always look at the fact of the case and the quantum and make a decision based on complexity and as to who we push forwards, whether we push forward big names from very well-known chambers, or if we go with more regional, younger arbitrators.
I'm going to interrupt you there, François, because I think we're risking sort of coming into the operation, and which is the last aspect to our talk. And I know we've spoken a little bit about this already. I think Haley's already spoken a little bit about the history of arbitration. I think you've spoken about the history of arbitration, the BVI. I can't let the moment go without just saying that in terms of history of arbitration in Ireland, it goes back to the late 17th century in Ireland. And like a lot of these things, it goes back to a ship. And there was a ship that went out from Dublin to Turkey called the Uzul Galley in the 1690s. And it was to go to Smyrna, which is now Izmir, as you know, in Turkey. And it never returned. And there was an arbitration panel formed to decide who was to bear the losses of that ship. And to everyone's amazement, 5 years later, it turned up in Dublin, and it turned up that the crew had been abducted by corsairs in North Africa and held captive for 5 years. But they ultimately returned, and another arbitration panel was set up. So we do have some history going back some period of time. But Haley, with that distant history, more recently in Ireland in the 20th century, what was the type of arbitration that was going on?
Well, I suppose it's really the traditional sectors, including things like insurance and construction, and as I mentioned, some conveyancing disputes. I think they were the main sort of sectors that were being used up. Yeah.
And I think one of the things which we wanted to talk about, and I could ask François and Hannah to come back on this in a few moments, is you know, why, if you like, why have our respective jurisdictions come into arbitration? Why do we think of that? And if I can just say a few words about that in terms of Ireland. Certainly the view for many years, I would say decades in Ireland, is that large construction disputes are not suitable for, if you like, heavyweight court litigation. And similarly, insurance disputes, and particularly what the area I work in, insurance coverage disputes, are something which are more appropriate for arbitration. And traditionally, as Haley says, in Ireland, disputes in relation to the interpretation and damages under conveyancing disputes, both commercial and domestic, tended to go to arbitration. But the move, and why did we seek to push it out more, was, I suppose, inspired, Haley, by the holding of ICA in Dublin. We hope it's going to be in Scotland now later on in the year. But Haley, could you talk a bit how ICA coming to Dublin really developed an appetite for broadening arbitration into a more international sphere for Ireland?
Yeah, that's right. I think in June 2008, the ICA conference was held in Dublin, and I think it was to celebrate the 50th anniversary of the signing of the New York Convention. And naturally, the preparations for that conference kind of cast a light on arbitration legislation here in Ireland and the potential for change in the area. And I suppose acted as a sort of trigger for us. And I think purely by virtue of the fact that the existing domestic legislation was from 1954 at that stage, it was felt by some that that was out of date and required modernisation in order to help Ireland establish itself on the international stage. And I suppose it was becoming more difficult as well to justify the arguments for having separate systems for domestic and international arbitrations. And I know that there were a number of seminars and discussions followed in order to debate that potential for change. And an arbitration bill was published in 2008 to coincide with the commencement of the ICA conference. I think after that, there were another number of seminars and symposiums to provide an opportunity for arbitration practitioners to express their views on that bill and building on any formal submissions that they had made. And one of the matters that I mentioned earlier is that one of the main points of debate around that time was how to accommodate the concerns that were in place at that time about the domestic arbitration law, and in particular in respect of the court's role within the framework of the model law. I think one good example of that is, for example, the power to remit an award and the case stated procedure provided for in the old legislation. And I understand that it was provided for in the draft bill at that stage that an award could be set aside on the basis of procedural unfairness and for an error on the face of the arbitral award. And some practitioners as well were wedded to the notion of a case stated under the old legislation and the comfort of knowing that you could refer a matter to the High Court. But ultimately it was decided that no additional grounds over and above what was set out in the model law were required. And so the bill ultimately chopped and changed and was pushed on, and the Arbitration Act was introduced in 2010, and which, as I mentioned, was very closely modelled upon the model law and is now the principal source of arbitration law here. And as you mentioned, Patrick, the Act has been successful here, and the placement of having a specialised arbitration judge in this jurisdiction has been very successful, because obviously a supportive and knowledgeable court is of great assistance in development of case law.
Yeah, and I think as well as that, there's been a greater involvement by Irish practitioners in international arbitration in the last 20 years. We certainly, when I was called to the bar, probably the most prominent of Irish international arbitrators was Niall Bunny, who worked in the construction field. But now there are many Irish practitioners who regularly sit as arbitrator under certainly ICC, LCIA, and also other investor state disputes as well. So the community together formed Arbitration Ireland and decided to get more involved in the whole thing. Francois, why do you think, or Hannah, maybe want to take why British Virgin Islands decided to go down the arbitration route?
Do you want to start, Francois?
Yeah. So, I mean, it all started, so we cannot go back to the 17th century because, you know, this was pirates' territory really at that time. But if you go back to the mid-80s, this is when the financial services industry in the BVI started to grow. And very quickly, the litigation started to come in. And very quickly, they realized that they needed to have a specialized court to handle this. And I believe the commercial court was created in the 90s, and it took a good 5 to 10 years for that commercial court to grow and take its place. And you know, fast forward 20 years, and the commercial court in the BVI is handling multi-billion-dollar cases that are global in nature, and you know, the legal sector in the BVI is generally really sophisticated with, you know, QCs from London coming in and out, and a lot of experts locally as well who live in the BVI. And back in 2005, 2007, a few prominent lawyers here in the BVI started to get involved in international arbitrations, not necessarily in the BVI. I mean, there were a few ad hoc ones here in the BVI, but in London and in the US and so on. And they started talking about the fact that international commerce was moving that way, and that a lot of the disputes that we were seeing were likely to move towards or gravitate toward arbitration over the next few years. And so that's when they created a work group, I believe that was 2007, to look at what was required to morph what was essentially a litigation jurisdiction into being a one-stop shop dispute resolution jurisdiction, and add arbitration and mediation. The proposal was made in 2011 to government, and they embraced the idea straight away, and then the act was drafted and published in 2013. And through the act that came into force in 2014, the institution itself was established. And so it's that work group of international practitioners, both local and based abroad, that came up with that framework and that plan to transition the BVI into arbitration. Do you want to add anything, Anna?
Yeah, I think to that I would add that the way now arbitration is taught, it's just that it's the normal way to resolve international disputes. So it's kind of very natural for parties to want to do arbitration, especially in high stakes contracts. And I think that's great that the BVI decided to have its own arbitration center and team and rules to help the users, because when you look at the number of BVI companies worldwide, it's kind of overwhelming. And a lot of those BVI companies actually are entities that come from other entities incorporated in China or Hong Kong. So you have a lot of those Asian disputes. And that's where arbitration makes sense, because it's more tailored to international commerce, and it's more efficient and more quick most of the time than litigation. So I think that's also why the BVI wanted to have a center here.
We're moving, I think, now to what is certainly for me the most interesting part of our discussion, the issue of how you promote yourself. Certainly from Ireland's point of view, that is an issue we're greatly interested in. And just to set the context to this, we are both in what are small regional centres. Ireland's aim is to make itself a regional hub in Europe for the provision of legal services across a range of sectors. The British Virgin Islands at the moment seeks to promote itself in what we're talking about here as a regional hub for international arbitration. And I know that you have established an arbitration center. You've established a set of institutional rules. You have, as we've discussed, a panel of arbitrators. You administer arbitrations. And we, if you like, have none of that. And so I wanted to explain a little bit about the thinking and how it's evolved here in Ireland, and why we've chosen to go down that route. And then maybe hear from you about why you've taken a different route and how you see that working out. So if you like, I suspect that subconsciously, at least, some of the choice of the UNCITRAL model law in Ireland was a way of not just using a very effective arbitral law, but also a way of differentiating ourselves or diverging from the United Kingdom. Because certainly when I was in law school, all of the arbitration jurisprudence and practice I learned was based on the UK system. So it's very hard for Ireland to mark itself if you're producing exactly the same product as the UK. So to some extent, I'm sure even at a subconscious level that was part of the thinking. But we chose at that early stage when the 2010 Act was introduced and therefore it applied to everything, we chose not to set up our own arbitral institution, our own panels to administer arbitrations. And although I wasn't involved in, if you like, a decision making at that stage, my understanding is that the feeling was that there wasn't really room at that time for an additional arbitration institution in Europe. And the context to that is that we have the PCA, which was established at the end of the 19th century in Europe. We have obviously the LCIA, which is well over a century in existence. I think it dates back to the early 1900s. You then have the ICC, the Stockholm Chamber, the Swiss chambers, all with well over a century of administration of arbitral disputes. So all of those are really within 1 hour's plane flight of Dublin. So I think the thinking was that it was going to be difficult, if you like, to create a buzz around a new arbitral institution in Europe in circumstances where you had all these other competing factors. And therefore, what we sought to do instead of creating an arbitral institution was to create, if you like, an ecosystem which made us arbitration friendly. To have lawyers, both barristers and solicitors, who are experienced in arbitration, to have an association of which we have Arbitration Ireland, which actively promotes the use of Irish law and Dublin as a seat for arbitration, and to try and make Dublin a more attractive place for arbitration to take place, rather than, if you like, asking people to put it into their contracts. Now, I know, Francois and Hannah, from talking to you, there's quite a different dynamic going on in the British Virgin Islands in terms of why people, first of all, you don't have all those institutions around you to compete with. But I know from talking to you beforehand, there are other factors that sometimes people were traveling even further away to deal with arbitrations that could be dealt with in your region. So perhaps you tell us a little bit about that and your different experience.
Do you want to start, Hannah?
Yeah, sure, I'll start. And I think that would echo what I just said earlier about the Hong Kong companies and Chinese companies. For example, the third nationality, party nationality at HKIC, the Hong Kong International Arbitration Center, is BVI. So there's a lot of BVI companies that choose to do their arbitration in Hong Kong. The thing is, they could do it here in the BVI, and it will be easier for enforcement reasons. So for us, I think the competition is not just what's in the Caribbean, because there are other centers in the Caribbean. It's also all the other institutions worldwide, like Hong Kong, for example. And I think what we're trying to do in the BVI is obviously try to help those BVI companies to resolve the disputes, but also be available for the Americas, either North, South, Latin America, and the Caribbean in general, just so they have an available center to go to. François, if you want to add anything to that.
Yeah, I mean, So you're right. We don't have the LCIA and the ICC next door. So at the time where we moved into arbitration, a lot of other Caribbean countries were trying to get into arbitration, and had tried for the last 20 or 30 years, and the BVI was just quicker. It's a very agile country when it comes to making those legislative changes, and everything relates to the financial services industry. BVI companies, like Anna said, are involved with business everywhere in the world. I mean, you mentioned BVI being the third nationality or jurisdiction of parties involved in Hong Kong IAC arbitration. I think that it's number 12 jurisdiction in, or 12% of arbitrations done by the LCIA involve a BVI entity. And so if you go to market with a really flexible legislation that has some quirks that make it even more attractive in a geopolitically neutral jurisdiction that is not the UK, that is not China, that is not Hong Kong, and offers you the flexibility to have the place of arbitration London or Hong Kong, but administered in the BVI by the BVI and the supervisory court being the BVI commercial court, then you actually have a really good value proposition. And we obviously want to take on that business. We obviously want to become the first point of the number one, if you wish, institution in the Caribbean, because the Caribbean, as you may know, is a really fragmented region. I mean, Jamaica has a model law based arbitration act. I think the Bahamas and Caymans are getting there. Barbados is kind of getting there, but other jurisdictions have ancient legislations and no institutions. So we'd like to become a beacon, if you wish, of arbitration in the Caribbean because of where we are. The Americas point that Hannah raised is quite interesting. There are a lot of disputes between North American companies and South American companies that end up in London or Hong Kong or Paris. And what we're saying is, well, if your Peruvian company doesn't want to,
when you think of it,
but if you've got a Peruvian company and a US company, and the Americans don't want to go to Peru and the Peruvians don't want to go to Miami, then they don't have to go to London anymore. They can just get to the BVI in less than 4 hours, and it's on the same time zone, so they can FaceTime their kids when they're done with a hearing that day. And they'll be dealing with arbitration using recognized rules, recognized jurisdiction, and a commercial court that gets it. And so that's the value we're trying to sell on the Americas axis, if you wish. I'll stop talking now.
Yeah, I was just going to ask you, just following up on that, because I take it that when you like most arbitral institutions, you are administering arbitrations which are subject to many different jurisdictions' laws. So the contracts are subject to US law or English law or Hong Kong law. That they're not all subject to British Virgin Island law.
Yeah, absolutely. Absolutely. Yeah. I mean, our most recent case that we registered here, it was BVI law. It was in between two BVI companies, but there's another one with a hearing happening very soon. And yeah, it's English law. So yeah, it really depends. It could be any type, could be US law as well. It could be, could be whatever the party decided in the contract.
So the key thing for you is to try and work out how you can persuade the corporate lawyers to include your institution as the go-to institution for disputes. I'm just wondering how you go about that. What's your strategy for that?
Absolutely. Bribery.
No, it's so let's put it that way. that's the trick. That's precisely the trick. And when you are a new institution or a new seat, or when you start, you're trying to sell a new jurisdiction when it comes to arbitration, you're trying to take a bite of a pie that has been on the table for quite some time. And the players, the participants, have been around that table for quite some time. So when I go to Miami and I present to law firms, I'm not saying that Miami is a bad place to have an arbitration. I'm saying that Miami is a great place to have arbitration. But if, when they're negotiating a contract, the opposite counsel doesn't want to have Miami or the AAA, or then people need to start thinking about the BVI for those contracts that may involve North and South America. And it's the same in Hong Kong. When I'm talking to law firms that are advising Chinese clients in Hong Kong, what I'm saying is Hong Kong IAC is not a bad institution. It's actually a great institution. So if they manage to get it done there, fair enough with that. What you don't want is those Chinese clients having to go to Paris or Singapore. They might as well do it in the BVI, with a place of arbitration being Hong Kong, because the assets will be in the BVI or in BVI corporate structures anyway. And so really, it's not a healthy competition. I'm not trying to say what you've been doing for the last 30 years, doing LCIA arbitrations is a bad choice. And that may well remain your default setting in your template contracts. But if, as part of the negotiations, you're having problem negotiating the arbitration clause, then you may wish to consider the BVI as a modern and efficient jurisdiction to resolve your dispute that may be highly relevant to the contract at hand. And I think that's the pitch, really.
So in Ireland, we've got a slightly different approach, and I suppose part of the different approach is because we don't have an institution, and part of it is a choice. So rather like the BVI, Ireland is the leading centre for the domicile of funds, second largest centre of asset management in the EU after Luxembourg. I think third or fourth largest in the world. So there is a huge financial services industry in Dublin. We've been the benefit of a lot of movement from the United Kingdom after Brexit. I think Dublin is probably the city that, in terms of number of companies moving to it, has had the largest move to it. And then, as well as that, we have, quite separate to that, we've got a very large, we're the world's leading center in aviation finance, and we've got a large pharma sector, we've got a large IT technology sector, we've got a large medtech sector. So there's a lot of indigenous and multinational business based in Dublin. And I suppose our task at the moment on the Irish government's project, which is called Ireland for Law, is to promote the use of Irish law to European and international business, to promote the use of Irish lawyers for transactions and advice. And the one that we're interested in is the promotion of Irish dispute resolution for international companies' business disputes. And we see, rather than asking people to incorporate a dispute resolution clause specifically for Irish law, we see those three things coming together, is that if international business gets comfortable with using Irish law for its contracts, almost by default, Irish dispute resolution, whether that would be in the commercial court, which is established since 2004, or by way of arbitration, but they will fall into the picture. And similarly, that if international businesses are using Irish lawyers for transactions or advice, that dispute resolution will come here almost in a kind of organic way, that businesses if you like, the international businesses in Dublin will feel more comfortable using Irish dispute resolution. And I suppose you have partially the same dynamic in that you have so many financial services businesses based in the BVI that if you have a product available to them, it can always become natural for them to choose BVI dispute resolution.
Yeah.
I don't know if that. No, I just I see we're coming up to 10 to 6. I don't know if I think we allocated an hour to the whole webinar. I don't know, did anyone want to ask any questions? I see there's some number of participants there. I don't know if anyone has any questions to ask. I'll wait a few moments before I say that.
So I'm just checking now.
Even when it's done by text, people are being shy about asking questions. It's a familiar complaint.
So while we wait, I just wanted to say something. I think, you know, historically, arbitration has centered around, you know, New York and well, Washington a bit, and Paris and London. And then, you know, in the 90s, Singapore and Hong Kong, you know, joined the dance. And then it stayed like that. I mean, you had a few centers, obviously, like Vienna or Stockholm and a few others. But it's the realization by a lot of jurisdictions that they had not only the skills in terms of the legal, you know, practitioners operating in that jurisdictions, but also the business acumen and the business contracts around to get into arbitration and to propose to the business world alternative dispute resolution places and or seats. It's a brand new phenomenon. I mean, it started 10 years ago. And, you know, I think this is moving in the right direction. You know, it's been too long. Like, if you look at African disputes, for example, they've been handled in Paris and London forever. And there is no reason why Kigali, or, you know, the Kigali International Arbitration Center shouldn't be able to grab some of that work, or the centers in South Africa and so on. And I think that change in the arbitration world is here to stay, and I think there will be more regional and local arbitration centers. And like Brazil, for example, when they started 20 or 30 years ago, they'll probably start domestic, you know, to handle domestic caseload, but they will grow into international arbitration centers. And that's the trend that seems to be in the market right now.
Yes,
and it's a good trend.
My perception is that it takes, you know, 20 years, perhaps, certainly 10 to 20 years to create a real movement in this area. It's very difficult to see a movement in less than that. And I think if you look at Singapore, it was first established in 1991, and really they started marketing in a more active way in the early 2000s. And I don't have the exact figures off the top of my head, but I think it probably took about 10 years to get up to 100 cases a year. And now, you know, it's exploded for Singapore. It's one of the leading arbitral centers in the world. If you look at a younger center, the DIFC-LCIA, in the last couple of years is now developing a very, very substantial caseload. Whereas 5 years, 10 years ago, it was much quieter. And in a way, I talked at the beginning about our ambition is to create a regional legal services hub in Dublin. And when I say regional legal services hub for Europe, we see that again as a long-term project. It's going to take 10 years, it's going to take 20 years, but it will develop if you have the support of the practitioners, if you have the support of business, and you have the support of government, which all three important factors. And I suspect the same vision is required for the BVI. It will take time, but if you have the support of the local community, if you have the support of business and the support of government, it will succeed over time.
We've got a few questions.
Yeah, we have a few questions.
So who the shy
Which one do
people
you-
came in.
Good. So I'll read the first one. What other ways can Ireland and BVI cooperate going forward, perhaps with other jurisdictions, to raise the profiles of the jurisdictions for arbitration and to get out the kind of messages to potential users of the jurisdictions that you have been speaking about today?
Well, that's from Barry, I think.
It is from Barry.
First, I'm delighted that Barry, you're watching, and Barry has been over here to Dublin. I've shown him around our legal quarter. In terms of cooperation going forward, well, I think the most important thing for centres like Dublin and the BVI is actually to get out there, to be present at events like London International Disputes Week, like Paris Arbitration Week, like ICA, because certainly I found, and I'm involved in a broader promotion of Ireland as a legal services hub, is that you'd be amazed how many people don't know about the smaller jurisdictions. And it's obviously been difficult with COVID, difficult to get out and, if you like, pound the streets selling your country. But I think that is the single most important thing that we can do is to create an awareness in countries around the world of the presence of smaller arbitration hubs. In terms of cooperation, my own experience both in promoting commercial courts and in arbitration is that joint seminars and webinars are a great way to promote it. And the reason I say that is that if you have people from 3 or 4 different places, you'll get a couple of people from each of those places watching events or coming to events. So my experience is that the more, if you like, the more competing venues you have on events, the more likely it is you get a broad range of people there. Yeah. François, do you want to come back in? And BVI International Arbitration Week, I wasn't aware of that. Maybe François, you tell us a little bit about that.
Yeah. So to answer Barry's question, we didn't know each other 3 months ago. We now know each other, and we're going to continue that conversation offline, and we'll hopefully have other seminars and webinars in the future. It's also about using the practitioners around us, and you know, in the BVI we've got the BVI Arbitration Group, and that's people in the BVI, practitioners in the BVI and abroad, that help the institution to sell the BVI as a jurisdiction. And I think, you know, spreading the message about not only the BVI but other smaller centers is key, and we should be working on that going forward. There were a few other questions, so I think I need to.
Yeah, maybe the last one of Barry asking if Arbitration Ireland is planning to join the BVI International Arbitration Week. Well, we haven't announced it yet, but yeah, we will have the BVI International Arbitration Week during the first week of November. Obviously, we will invite you guys, our 2 co-panelists and attendees, obviously. So you'll see information on that very soon.
Yeah.
There's a couple of questions there which are specific to the BVI. One about interim measures under your rules.
Absolutely.
Yeah, and Haley and I we're working on a piece in relation to financial services arbitration. That's a key issue in financial services arbitration. Secondly, about from colleague of mine here in Dublin, Gordon Barry, who I sat for many years on the ICC National Committee with. He wants to know, are there particular sectors that favor arbitration? Well, maybe both of you would take that question, or those 2 questions.
Yeah, I'll start with the anonymous attendee who asked the question about the interim measures. So under our 2016 rules, Article 26 is about interim measures. So we have already a provision about that. We do not have provisions about the appointment of emergency arbitrators, but we are currently working on amending the rules. So we should have new rules by the end of the year, and we will definitely add an emergency arbitration provision.
And tell us about the sectors, if you like, that favor arbitration.
It's too early to call. We've had, I mean, it's a double question. So we've had cases from a wide range of sectors, and it's too early to say. I think, you know, a lot of our cases were related to the financial services sector, and the financial services sector is involved across the range. So the latter part of the question is slightly more interesting. Sectors that we have struggled to attract. I think trust arbitration as a type of arbitration is something that we have not attracted, despite the fact that there are a lot of trusts in the BVI. And that's a function of the Trustees Act not being perfect for trust arbitration right now. The Trustees Act was just upgraded, and there is a working group looking at the arbitration part of the Trustees Act, and hopefully there will be a further amendment later in the year. So hopefully, you know, by 2022, we'll be better equipped to handle trust disputes, and we'll start seeing a more steady caseload of that.
Just, I see Barry has another question there. You might, like he's coming in just to talk about the issue of confidentiality in the BVI and arbitration.
Yeah, I mean, this is, I didn't want to make it too long. When talking about the ancestral model law and the way we got into arbitration, the BVI has specific perks. So for example, every arbitration is obviously private, apart from if, you know, the parties agree otherwise, but court orders related to arbitration are also private and confidential. Whereas in London, for example, you've got to seal them, and people do forget. And so there are, you know, not only did we get a model law-based arbitration act, but you had a lot of opt-ins and opt-outs built into this, and a lot of ancillary clever touches to other pieces of legislation to ensure that the BVI as a seat for arbitration was perfect. I could talk about a piece of legislation that enables persons coming into the BVI to carry out or support an arbitration, not to have to get a work permit, for example, which is not the case in a wide range of countries in Africa and the Caribbean, for instance. So yeah, so you know, this is part of the things that you need to think about when you start to build a new jurisdiction from scratch, I suppose.
Well, I think we're coming up to the hour. I do have one question I want to ask you, which is whether your BVI International Arbitration Week is in person or online, because I think we could all do with a little bit of your weather when we get to November.
It's going to be hybrid. So there will be people here. You're more than welcome to join in person. The BVI is now reopening its borders. So if you are vaccinated, you will be basically able to get a test upon arrival and quarantine for like 24 hours until you get your test results. And you know, it's the sailing capital of the world. So if you do come for Arbitration Week, I'll just make sure to take you out on a boat. But yeah, hybrid conference. So it will also be remote.
Well, I think that's probably everything. We're probably just closing up on time there.
Well,
I
thank you very
suppose,
much.
yes, on behalf of Arbitration Ireland, I'd like to thank you very much for letting us go tell you a bit about arbitration in Ireland. We have Dublin International Arbitration Day, which is later in November, and anyone listening on can log into that, and you're very welcome to come to that as well. Although I have to tell you that the weather will not be good and the sailing will not be good in Dublin in late November. So you'd have to put up with bad weather if you want to come here, but the conference is good. And hopefully, as Barry says, we'll be able to see you both in person or also just there's one or two final questions there. I think they're just asking is an important one, is the BVI part of the New York Convention?
Yes, we are part of the New York Convention.
An important clarification, I think, just to make.
Yes.
And we hope to welcome you here to Dublin. We hope to see you in the British Virgin Islands, and if not, we'll see you either in Paris or in Edinburgh at one of those arbitration weeks.
Sounds great.
Yeah, thank you everyone for listening in, and you'll be able to find the details of the BVI Arbitration Centre or Arbitration Ireland on the internet if you want to contact for further information.
Thank you very much.
Thank you very much.
Bye-bye.
Bye.